Welcome to the Senate Commerce and Consumer Protection Committee. Today is Tuesday, March 18th, 2025. We will begin today with Senate File 2216 and Senator Klein, two-year bill.
Thank you, members. And Senate File 2216 is the governor's proposal for Commerce Bill, which we'll be hearing informationally today and laying over. There is an A2 delete everything amendment, which we're not going to offer at this time, but members should refer to that as the framework for what is being discussed today. Madam Chair, I would turn it over to the Commissioner.
Thank you, Senator Klein. Commissioner Arnold.
Good afternoon, Chair Seeberger, Senator Klein, members. We have some slides to walk through our proposals, so thank you to Chair Klein for carrying this. For the record, I'm Grace Arnold. I'm the Commissioner of the Minnesota Department of Commerce, and with me today is Sam Smith, who's our Government Affairs Director. Thank you for inviting me today. I'll be walking through our proposed budget, which encompasses our agency's oversight of more than 40 industry areas in energy resources, financial institutions, insurance, and more. Our budget includes some cost increases as well as cost savings and budget neutral items to support Commerce's work in assisting and protecting Minnesotans across our state. So the first item we have is an operating adjustment. Like most state agencies, we have operating expenses that increase over time. Our general fund request is just over $3 million with 1.162 in fiscal year 26 and 1.84 million in the subsequent years. These funds go toward things like increases in compensation and insurance, increased costs of maintaining our current staff in a challenging labor market, and increasing IT costs. These are sort of, basic increases that go with the cost of doing business. We're also taking steps to identify cost savings. So we've reduced our agency footprint by decreasing our office space by 4,500 square feet with an estimated savings of $117,000 annually. And we're in the process of renegotiating our lease and are considering a substantial reduction in office space with that renegotiation. Other cost-saving measures that we've taken related to our office space include reducing leased office equipment, so that's like copiers, we just don't have as many, and eliminating TV contracts. I'll turn now to some of the specific proposals. The premium security plan we've discussed in this committee. It's a proposed extension of Minnesota's reinsurance program for the individual health insurance market. Reinsurance is a proven program that stabilizes market premiums, maintains enrollment levels, and ensures that consumers have meaningful choices in the individual health insurance market. Reinsurance works, but funding has been a challenge. Following the lead of other states, we propose instituting an assessment to ensure that there is stable funding source for the reinsurance program. Without this action, the premium security plan will be depleted, and Minnesotans on the individual market are at a significant risk of premium increases of 25% or more on the individual market. That means that people will lose health insurance coverage, fewer Minnesotans will receive primary care, and more people will rely on expensive emergency room treatment. Next, I'll move to our securities division. The Commerce Department has made significant process and technology improvements to support our Office of Securities in protecting Minnesotans who invest their hard-earned money in securities. With the current workload, our team of 2 examiners and 2 registration analysts cannot adequately support the large number of investment advisors, investment advisor representatives, broker-dealers, and agents registered in Minnesota who manage more than $11 billion in investment assets in the state. Our staff ratios are not comparable with similar states. For example, Wisconsin oversees a market that's about on the same scale as Minnesota, and they have 3 times as many examiners. We're proposing only to increase transfer fees and exempt reporting advisor fees, so we're not increasing all licensing fees. We'll charge a small fee on a narrowly focused scope of activities to allow the department to provide additional and significant resources to protect Minnesota investors. Next, I'll move to the Earned Wage Services Act. In recent years, Minnesota has seen the arrival of earned or early wage access or buy now, pay later products that have arrived in the marketplace. These products have begun to replace payday loans as a preferred short-term financing product, often used by Minnesotans experiencing financial instability. Despite high usage rates, these products are not consistently regulated by state consumer finance agencies. Our revenue-neutral proposal updates state law on consumer small loans to reflect the practices of the earned wage access industry. We'll also increase examination fees for the financial institution's special revenue fund, hire additional staff for licensing and exams in this space. We consider these products to be loans given their fundamental characteristics. So that includes an expectation of repayment and the imposition of fees as a condition of credit. Our proposal brings these transactions under the consumer small and short-term loan statutes. And so EWA providers would likely need a regulated lender license, or if they choose to limit advances to the maximum of $350, an enhanced version of a consumer small lender license under Section 47.60. We understand that these products are important to many Minnesotans who may have limited financial capacity. Our aim is not to eliminate this product for those Minnesotans, but to provide transparency and protection through disclosure and an annual percentage rate threshold. It's important to all consumers that they're made aware of the fees they're being charged, and it's good public policy and results in trust and a competitive market. Next, I'll move to the electric vehicle supply equipment testing. As more Minnesotans are driving electric vehicles, we must ensure that consumers are getting what they pay for from mobile charging stations, just as they do with gas stations. According to the U.S. Department of Energy, there are 2,276 charging ports across 862 stations in Minnesota. While there is an effort by electric vehicle supply equipment charger producers to develop uniform standards, there is currently no regulatory oversight of this industry in Minnesota. Our Weights and Measures Division, which has proven value by inspecting gas stations and many other things to ensure consumers are getting the gas they pay for, they would now test and inspect EV charging to ensure consumers are getting the EV charge that they're paying for. So same concept, just applied to EVs. Funding for the staff necessary to do this work on a routine basis would come through a fee of $100 per charging port collected from businesses undergoing an EV inspection, EV SE inspection. So finally, I'll talk about our benchmarking proposal. The Affordable Care Act at the federal level requires health plans sold on the individual and small group markets to cover a comprehensive set of what's called essential health benefits that insurers must cover. The specific items for Minnesota's EHB or essential health benefit list are determined through a process called benchmarking. That's where the scope of benefits is determined and must be in alignment with a typical employee-based plan. States are encouraged to periodically review and update the benchmark plan to ensure it reflects the current state of the insurance market. Whenever a state mandates a health benefit not covered by the essential health benefit plan, then the state must cover the increased premium cost through what's called a defrayal payment. Minnesota has not updated our benchmark plan since 2013, and the department plans on creating a new benchmark plan based on CGIP coverage and submit it to the federal government in May of 2025. This updated benchmark would be required for plans starting in January of 2027, so there's a process that's laid out by the federal government to make this change. The new benchmark will include some benefit mandates that currently require a defrayal, including PANS and PANDAS, rapid whole genomic sequencing, orthotic and prosthetic devices, and biomarker testing. These added benefits will reduce the state defrayal payments by $3.969 million annually starting in fiscal year 2028. And that is our presentation. You can reach out to our government affairs team if you have specific questions. I can take any other questions, unless you want to go to OCM.
Thank you, Commissioner Arnold. Are there any questions or comments from members of the committee? All right. Seeing none, I will call Eric Dibble to talk about the Office of Cannabis Management. Director Dibble, when you're ready, please introduce yourself and begin your testimony.
Thank you, Chairwoman. My name is Eric Dibble. I'm the Interim Director of the Office of Cannabis Management. Here today with a quick discussion on our 4 budget pieces. They are relatively small. We discussed them a few weeks ago, and so sort of from the top to the bottom, we also have an operating adjustment that, like the Department of Commerce, that operating adjustment is designed to help us cover the increasing cost of labor, insurance, physical space, and technology. We also are seeking to renew the Can Renew grant. We're seeking an extension of the date by which we can expend funds that were allocated for this biennium. We are currently in the RFP process for the first year of the Can Renew grant. That closes on March 24th. And so we want to make sure that anyone who was awarded a Can Renew grant but has not yet been able to get into a place where our grants team feels like they're ready to accept funds, that we can move the execution of those grant agreements back into the next biennium. We're also seeking a variance for our testing facility licenses. At present, those facilities are required to get ISO certification. It's an international standards organization. The standard they're required to get is related to calibration and measurements. This can be a barrier to entry into the market. There's a cost attached to this, but the agency is willing to cover the cost in order to help us accelerate the market with testing facility infrastructure so that we can ensure products are safe. Finally, we have an adjustment to the social equity criteria. This is based on feedback we got from constituencies during the first application window, where persons who had been justice involved through either a cannabis crime, but had that adjudicated either as a juvenile or through what's called a stay of adjudication, where they are able to avoid the consequences of a conviction. Those people are definitionally excluded from a conviction, and therefore were not able to be social equity verified, even though their experience with marijuana and the Justice Department impacted them in ways that are similar to those persons we've identified as social equity applicants based on actual convictions. So that is the 4 requests, relatively small.
Thank you, Director Tauble. Any questions or comments from members of the committee? All right, any closing comments, Senator Klein?
Thank you, Chair and Committee.
All right, Senate File 2216 will be laid over.
Waiting for a chief author, brief recess.
Has some provisions regarding, actually, this is a very long bill, Mr. Chair. So I'm not gonna give the section by section overview of it. I will refer to Mr. Tauble, who will do that. There's a lot of details, but just in general, just for your information, it's designed to just kind of update our statutes and provide some greater ease of access. We have the tribal compacts that are coming in that are going to include a medical cannabis program, and so this aligns the new statutes that are needed for that purpose.
Thank you. And before we go to Director Talbot, Senator Dibble, I'm going to get your author's amendment on board. Senator
thank you.
Frentz offers the A1 as an author's amendment. All in favor, say aye. Aye. Opposed? Bill is in the form that you wanted. Senator Director Talbot.
Thank you, Chair. My name is Eric Tobble. I'm the Interim Director of the Office of Cannabis Management. As Senator Dibble noted, this bill does a couple of things in a lot of pages. Primarily, we fix a few problems that we have identified that will create issues for access to medical cannabis for patients. One of which is that at present, virtual consultations are allowed so that a patient may speak with a cannabis consultant or pharmacist virtually, but the statute requires that the label identifying it as medical cannabis and as medical cannabis for that patient be affixed by that pharmacist or cannabis consultant, which seems to make it hard to do virtually. And so we clean this up by allowing that if a virtual consultation occurs, someone other than the cannabis consultant or pharmacist could affix the sticker. We also, as Senator Dibble noted, address tribal reciprocity. So a number of tribal nations have medical cannabis programs. We want to ensure that those patients will continue to have access to Minnesota's medical cannabis program. There is reference to this in the current chapter on medical cannabis in 152. We're bringing this into 342, so that is that piece. And then finally, we increase and strengthen protections for members who are currently on the registry. So at present, registry protection includes things like discrimination in housing, healthcare, employment, and the like. This bill does an increase in the sort of fee that can be awarded for someone who violates it. Also includes some injunctive relief. Our customer service team gets about 25 emails a week from patients who are concerned about things like housing, healthcare, and employment. And so we think this will be a great way to help solve some of those issues that our medical registry patients are dealing with. Thank you.
Thank you, Director. Members, this is the only one of the cannabis policy bills that needs to go to a different committee. It'll go to Health and Human Services. The remainder of these can be laid over and remain within the Commerce jurisdiction. Are there any questions or comments for the Director or the author? Seeing none, Senator Wickland moves that Senate File 2371 is amended, be recommended to pass and refer to the Committee on Health and Human Services. All those in favor say aye. Aye. Opposed? Bill is on its way. Senator Dibble, we will move to 1729.
Thank you, Mr. Chair. Senate File 1729 is a series of minor changes related to the licensure and regulation of lower potency hemp-derived products. It offers clarity and consistency in the governing statutes, allowing for more effective enforcement and improved expectations for business and consumers. The changes align the requirements for lower potency hemp edible licenses so that the expectations are the same between retailers and manufacturers, ensures regulations for labeling are consistent between products to improve effectiveness of enforcement responsibilities and improve customer understanding, and adds clarity for enforcement of non-intoxicating cannabinoid products. And with that, I will toss it over to Mr. Taubel.
Director
I
Talbot.
assure you I'm familiar with the contents of the bill, but he's better at getting it from his head to his mouth.
And before we go to Director Talbot, once again, we'll adopt the A1. Senator Seeberger offers the A1 as an author's amendment. All those in favor say aye. Aye. Opposed? Amendment is adopted. Director Talbot.
Thank you, Chairman. As Senator Dibble notes, these are fixes oriented towards the regulation of our low-potency hemp edible products market. Specifically in the non-intoxicating space, currently it is illegal to label a product as available for sublingual application. There's no real health reason to prohibit sublingual application of non-intoxicating cannabinoids, and it's a regularly occurring product in the market. So these changes reflect that reality. We also move from the lower potency hemp. In lower potency hemp edible, retailers are required to follow local and state fire and building codes. There's no reciprocal requirement in the low potency hemp edible manufacturing space. We think that's a wise choice to ensure fire and safety codes are met by those manufacturers. And then finally, in the old lower potency hemp edible space, the use of QR codes was quite common for conveying information about products and how they tested and what's in them and those sort of things. In 342, we're moving away from that, but there was one relic, the non-intoxicating hemp-derived topicals that had allowance for a QR code. So we simply removed that so that all products sort of exist in the same space with the same marketing and packaging requirements.
Thank you, Director. Members, questions on 1729? There are none. Senate File 1729 as amended will be laid over. Senator Dibble, Senate File 1730.
Thank you, Mr. Chair. 1730 comes to you from state and local government. It's a fairly simple and straightforward bill, which simply defines the Office of Cannabis Management as a state agency, which will then allow it to sit at the Minnesota Indian Affairs Council for the purpose of the conversations that occur at that table.
Thank you, Senator Dibble. Director Tauble, anything to add to the summary of this fairly concise bill?
Chairman, no additional thoughts.
Senator Rest.
Mr. Chairman, Senator Dibble, any particular reason why all these bills are offered separately rather than as part of one bill? I don't quite understand that.
Senator Dibble or Director Tauble for the strategy on the separate bills, I guess.
Mr. Chair, I don't have a good answer to Senator Rest's question. I assume at some point they'll be rolled into a larger bill that will come out of this committee. But if Director Tauble knows why we chopped it up into a bunch of different bills, I would be interested too.
Director Tauble.
Mr. Chairman, Senator, thank you for the question. We chop them up topically in terms of what portions of the sort of universe of hemp and cannabis that we cover, recognizing, here we were lucky enough to get a single author, and some other places we've had to get multiple authors and are divided by interest, and so we've had them introduced separately.
Senator Rest.
Mr. Chairman, I get uncomfortable with that, that we do not have a comprehensive proposals. The Housing Committee is doing the same thing. They have 10, 15 bills, all on separate little items. And it, quite frankly, is very puzzling and doesn't make any sense to me. But it is what it is. Thank you, Mr. Chairman.
Other comments or questions for the Director or Senator Dibble? Senate File 1730 will be laid over. We move on to Senate File 1731. Senator Dibble.
Thank you, Mr. Chair. Senate File 1731 proposes minor changes related to the current law's application requirements for cannabis business licensure to improve the applicant experience, remove duplication and subjectivity, and build clarity for better implementation of the application process. And
Director
Chair, there's
Tauble.
a fiscal note that has been has been prepared for this, and it shows a no cost.
Members should have the fiscal note now in front of them that shows no cost. Director Tauble, anything to add to a summary of 1731?
Mr. Chairman, only that these are existing requirements in statute that had both a permissive and mandatory. We've just consolidated them. And then the second requirement that we're striking is 2 signatures for corporations. The application itself requires multiple times that the applicant attest that they have the authority to enter into these agreements or make these attestations. And so it's a duplicative requirement that doesn't add benefit for the application process.
Members, questions or comments on the bill? Senate File 1731 will be laid over. We go now to Senate File 2370. Senator Dibble. 2372.
Thank you, Mr. Chair. So the top line of Senate File 2372 is that it is another housekeeping bill which targets clarity and consistency and technical fixes proposing a series of technical changes that will add consistency and clarity throughout cannabis laws in Minnesota governing the adult use industry, the medical and hemp-derived programs. A series of changes improve the office's work to effectively implement the framework to launch and sustain a well-regulated market and provide clear information to members of the public and impacted industry. Some sections amending Chapter 152 are changes that align with the comparable section in Chapter 342 so that there are no gaps between the current medical program under 152 and the future medical program under 342, and align authority of the agency of the medical program from the Department of Health to the Office of Cannabis Management, so the office has full authority to run the medical program that exists under 152, should there be a delay in transition, and that would prevent any gap in access for medical patients.
Is this the amendment? Senator Dibble, before we go to the director, we have an author's amendment in A1, which looks technical and is a single line. Senator Wickland offers the A1 as an author's amendment. All those in favor say aye. Aye. Opposed? Director Tubble.
Thank you, Chairman. Not much to add. This is truly a housekeeping bill where we've identified some typos, inconsistencies throughout 342 that we think need to be addressed. And then, as Senator Dibble noted, we also wanted to align Chapter 152, which is the current medical program, with changes made in 342. We anticipate medical providers will be operating under 342 in the coming months with licensure. However, recognizing the importance for access to medical cannabis for medical cannabis patients, we want to ensure that the office has all of the tools available to it throughout the next year. Thank you.
Thank you, Director. Senator Dibble, please accept the gratitude of the chair and committee for sort of taking on this role in the Senate of cannabis policy. We know it is in good hands. Are there questions or comments on the bill? Members, Senate File 2372 as amended will be laid over. No more business. There's no more business before the committee. We're adjourned.
Thank you, Mr. Chair and members.